Hello, everyone, and welcome to our Anti-Money Laundering Enforcement Trends webinar. You may be familiar with how our webinars work, but just in case, we want this session to be as interactive as possible. We've already had a good number of questions sent in advance, and we will be picking those up, but you can also submit live questions by clicking on the question link below this video. You can include your name with questions, but you also have the option to ask anonymously. We will try and answer your questions as we go through the webinar. This stream will be available on CatchUp, and so will the slides and the links to the relevant web pages on the resources page for this event. Feel free to share this with your colleagues. I'm going to introduce our speakers today. I'm here today with Head of AML Investigations, Christian Schotten, and Anti-Money Laundering Investigation Manager, Nicola O'Brien.
Good afternoon, everybody. So the aims of today are we're trying to highlight what we're seeing in firms and issues at client and file level, offer some insight into our enforcement action, and show you some of the cases which have resulted in financial penalties. So over to Nicola to discuss professional enablers.
Hi everyone. So in a recent publication, the NCA stated it was concerned about professional enablers, which includes law firms and those that work within them, and how the UK's lawful economy can be exploited by criminals using the expertise of a professional. Our next slide goes on to define the NCA's definition of a professional enabler. It is an individual or organisation, and in this context, a lawyer, solicitor or firm that is providing a professional service that enables criminality. Their behaviour is deliberate, reckless, improper, dishonest and/or negligent through a failure to meet their professional and regulatory obligations, thereby allowing or facilitating criminal activity to take place. The NCA state that there is a sliding scale from being complicit in criminal activity to being negligent. A professional enabler may be someone who forms part of a criminal network and has knowledge that they are facilitating criminal activity, or it may be someone who fails to implement and adhere to proper controls and procedures to detect criminal activity, such as money laundering and terrorist financing. Some are willfully blind and take a no questions asked approach, while others do not meet the standard expected of someone in a position of trust and subsequently fails to meet their obligations under the MLRs. Their conduct falls short of the standards set by their regulator or AML supervisor. In this context, us, the SRA. Over to Christian to discuss AML at the SRA and firm controls.
So we have 3 bespoke anti-money laundering teams at the SRA within the AML Directorate, which was formed in early 2019. The AML policy team, and they are tasked with liaising with government, other regulators and professional body supervisors, and producing our reports and guidance. The AML proactive supervision team, tasked with performing on-site inspections and desk-based reviews of law firms to assess each firm's compliance with the regulations. And the AML investigations team, tasked with investigating cases where breaches of the money laundering regulations may have occurred, leading to breaches of our core principles and code of conduct. Next, we'll discuss the issues we've seen at firm level. So, at firm level, we've seen a lack of AML controls and in some firms, very little in place whatsoever. Inadequate firm-wide risk assessments and policies, controls and procedures, a failure to train and supervise staff who work on in-scope matters, and when I say in-scope, I mean such as conveyancing or trust and company service provider work, and failing to pay sufficient regard to our warning notices and Treasury-approved guidance, which is specifically targeted at the legal sector. Moving on to firm-wide risk assessments. Firm-wide risk assessments, otherwise known as practice-wide risk assessments, have been a requirement since 2017, and they are needed by all firms who undertake work in scope of the money laundering regulations. These have been a legal requirement since the 26th of June 2017, when the 2017 regulations came into force, and the requirement to produce the risk assessment is set out at Regulation 18 of those regs and must be appropriate to the size and nature of your business. Each risk assessment must take into account information that we publish and address 5 key risk factors highlighted in Regulation 18, those being customers, countries or geographic areas in which you operate, products or services, the firm's transactions, and how your firm's products and services are delivered. If you have not identified the risks at firm level, it's going to be hard to get it right at client, matter, and file level, as the firm-wide risk assessment forms the backbone to anti-money laundering awareness and controls of the firm, which should then flow through your policies, controls and procedures, training regimes and customer due diligence obligations. Next slide. So as stated above, we're still seeing firms with no firm-wide risk assessment in place, despite this being a legal requirement for over 6 years. We published a warning notice in May 2019 to emphasise the requirements of Regulation 18. We produced extensive guidance and published this in October 2019, including a template which could be edited by firms if they wanted to use this as a starting point. We have stated that firm-wide risk assessments must be in writing, kept up to date and provided to us upon request. They must also accurately set out what risks each firm is exposed to and must also record the steps firms have taken to prepare their risk assessment. We also made the profession make declarations to us in late 2019 or early 2020 as to your compliance with Regulation 18. We also see cases where firms have downloaded our template, which is a starting point only, and either left it completely blank or not tailored it sufficiently to their own practice. Over to Nicola to discuss policies, controls and procedures.
So Regulation 19 of the MLRs 2017 is clear. Each firm must establish and maintain PCPs to mitigate and manage effectively the risks of money laundering and terrorist financing, which you have identified in your firm-wide risk assessment. Those PCPs should be regularly reviewed and updated, and you should maintain a record in writing of any changes to them and the steps taken to communicate those PCPs to the staff within your business. The PCPs must be proportionate with regard to the size and nature of your firm and approved by your senior management. They must include risk management practices, internal controls, approach to customer due diligence, reliance and record keeping. And further, you must monitor how your staff adhere to the PCPs and record how you've communicated those PCPs to your staff. But moving on, we are still seeing firms with no PCPs in place, and this is especially concerning for firms that have existed for some time, as even the money laundering regulations from 2003, so from as far as 20 years ago, mandated that each firm must establish procedures of internal control and communication to preempt and prevent money laundering. These regulations were strengthened by the 2007 regulations, and then again the current 2017 regulations, which stated you must establish and maintain appropriate and risk management sensitive policies and procedures relating to customer due diligence measures, ongoing monitoring, reporting, record keeping, internal controls, and risk assessments, and again how you communicate those to your staff. Consequently, this is not a new requirement or phenomenon. Firms have been required for the last 20 years or so to have some form of procedure and internal controls in place to combat money laundering and terrorist financing. But some firms are still getting this wrong, and as stated previously, have either nothing in place or a very poor grasp on what is required of them. Now we'll talk a little bit more about the LSAG guidance. So the Legal Sector Affinity Group guidance was first published shortly after the 2017 regulations came into force, and it gained Treasury approval in 2018. It has been updated a few times since and offers a really helpful insight into what your PCP should cover, and yet we still see big problems in this area. The current regulations state that where appropriate to the size and nature of your business, you must establish an independent audit function with the responsibility to examine and evaluate the adequacy and effectiveness of your PCPs, make recommendations in relation to those PCPs, and monitor compliance with those recommendations. We have seen a number of matters where firms have completed an independent audit, and it would have picked up on problems earlier, allowing the firm sufficient time to resolve or put those processes into place, and thus avoiding enforcement action by us. Another common issue we see is that some firms have robust PCPs, but unfortunately these have not been communicated to the staff who work on matters and transactions on a day-to-day basis, such that the PCPs are not being followed by the fee earners. Christian will explore this further in training.
So the current regulations clearly set out that you must take appropriate measures to ensure that staff are made aware of the law and regularly given training in how to recognise and deal with transactions and situations which may be related to money laundering or terrorist financing. You must maintain a record in writing of the measures taken and in particular of the training given to staff. This again is not a new requirement for firms, and the 2003 regulations stated you must take appropriate measures so that staff are made aware of the provisions and given training in how to recognise and deal with transactions which may be related to money laundering. This was again repeated in the 2007 regulations and strengthened again in the current 2017 regulations. Again, we are seeing that targeted AML training is not being given to staff, and yet it has been a mandatory requirement for the last 2 decades, or no records are being kept of what training has been given. Further, staff are not being trained well enough on the application of the firm's PCPs, such that employees are not aware of how to deal with each transactional matter that they work on. This can lead to enhanced customer due diligence, or EDD, not being performed when it should have been, failing to spot red flags during the course of the retainer, source of funds checks not being considered or completed, and matters have not been highlighted to the firm's MLRO. Our next thematic review is going to be on AML training within firms, and so look out for future publications by us on this subject. Now moving on to reports. The AML investigations team receives a number of reports each year relating to potential misconduct, which in turn have breaches of the money laundering regulations associated with them. Over half of the reports come via the AML proactive supervision team following their compliance inspections or desk-based reviews of the firm's compliance with the AML regulations. The rest are received from law firms self-reporting, law enforcement, other agencies or regulators, and some from members of the public. We record the reasons why a report has been made. So last year in 2022-23, there were 249 money laundering related reports received with 522 reasons attached, compared to the previous year where there were a similar number of reports, but only 393 reasons. This shows we are now investigating more potential breaches of different sections of the regulations than we were before. So we often use the word report to capture referrals made into our AML investigations team. Often these reports have more than one suspected breach of the MLRs that needs investigating, and these can change during the life of an investigation as we get more information in. On screen, you can see the most significant reasons for the reports that we've received. You'll see the numbers show that we receive a significant number of reports that relate to a firm's AML controls, but also where there may be breaches at client and file level. Just let you have a look at the numbers. So over to the next slide is issues at client and file level. The most common issues we see either at client or file level relate to the inadequacy of customer due diligence measures. CDD is mandatory and vital to combating money laundering and terrorist financing. Professionals such as lawyers can be right in the middle and facilitate actual money laundering, as highlighted earlier by the NCA, either by negligently failing to identify the risks or in rare cases where their actions are deliberate, reckless, improper and dishonest. It is key that each in-scope matter, conveyancing, TCSP work, etc., and client are treated appropriately from inception so that the necessary levels of CDD can be obtained by you. Now we'll move on to CDD.
Regulations 2812 and 2813 of the current MLRs 2017 clearly set out ways in which you can comply with the requirements to take CDD measures. The extent of the measures taken must reflect the risk assessment carried out by you under Regulation 18, so the firm-wide risk assessment, and your assessment of the level of risk arising in any particular case, and recognising that this may differ from case to case. In assessing the level of risk in a particular case, you must take account of factors including, among other things, the purpose of an account, transaction or business relationship, the level of asset to be deposited by a customer or the size of the transactions undertaken by the client, and the frequency and duration of the retainer. Regulation 2816 confirms that you must be able to demonstrate to your supervisory authority, that is us in this context, the extent of the measures that you have taken. Consequently, assessing and identifying risk from the outset is key. This will inform the level of CDD to be obtained, recognise that a case presents higher risks, such as where enhanced due diligence, known as EDD, would be required, and any other key factors that you should be alert to. Looking further at CDD and without listing all of the requirements of regulations 23 through to 36 of the current regs, you must identify and verify the client. You must perform ongoing monitoring of the transaction. It's simply not a matter of assessing and identifying risk at the outset and then thinking that your obligations under CDD are complete. You must perform source of funds checks when necessary to do so. The regulations do not specify when it is necessary or not to do so, but you should be alert to any higher risks which may make source of funds appropriate in that transaction. You must undertake CDD, known as EDD, when relevant to do so. The regulations specify that you must take measures to examine the background and the purpose of the transaction and increase the monitoring of the business relationship when EDD is required. The requirements are not prescriptive about exactly what must be included as a part of EDD, except for matters concerning PEPs, politically exposed persons. EDD may include things like seeking additional independent, reliable sources to verify information, take additional measures to better understand the client's background, ownership, and their financial situation of either the client or other parties connected to that transaction. And you must be taking further steps to satisfy yourselves that the transaction is consistent with the purpose and the intended nature of your business relationship and increase the scrutiny of the transactions, such as performing source of funds checks. And now Christian will move on to some of the common issues that we are seeing.
So yes, I mean, I talked earlier that we have over 200, I think it's 249 reports last year. And so the common issues that we're seeing on a lot of those cases are things like failing to know the identity of the client, whether that be a person or a body corporate. This can lead to failing to identify a PEP, politically exposed person, or a close known associate of a PEP, where EDD, source of funds and source of wealth checks are mandated, or possibly a client that is subject to sanctions. We also see firms not completing any client and matter risk assessments as required by regulations 28, 12 and 13. And this can lead to a catastrophic failing in the application of CDD or EDD. Firms treating client and matter risk assessments as tick box exercises, such that no application of thought is applied to the process, meaning inadequate CDD is performed in any event. Failing to check source of funds, when clearly, in view of the associated higher risks, those checks should have been performed. Fee earners relying on centralised risk and compliance departments. So this is probably for your medium to larger size firms, but where fee earners rely on the risk and compliance department, and sometimes vice versa, to perform certain elements of CDD. One thinks the other has it in hand, and overall the firm has performed inadequate CDD. And also having systems and processes that allow events to happen unchecked, such as receipt of funds or moving to the next stage in the transaction, rather than an automated stop being put to a transaction when an element of CDD has not been performed. So now we're going to move on to some case studies which have resulted in outcomes from our investigations team. So the first one we're going to talk about is Mrs. A. So this investigation concerned an individual who we'll call Mrs. A. The report was a self-report made by the firm where she worked. She was an experienced fee earner of circa 20 years practice and a partner too, at her firm based in one of its offices in the south of England. Her client was purchasing a residential property in London with a value of over £3 million, which was funded circa half by the client and half by a traditional lending-backed mortgage. She failed to follow her firm's PCPs, did not assess the level of risk appropriately in the transaction, leading to no source of funds checks being performed. This was isolated to one transaction, but the cumulative failings made this more serious. She did not use the firm's onboarding system properly, knew that over £1 million towards the house purchase was coming from a third party in the Far East, did no checks on those monies, and proceeded to complete the transaction with little or no elements of CDD adequately performed. She also failed to follow the mortgage lender's handbook too, by not disclosing the third party's funds to the mortgage lender. In mitigation, this was a client known to her who had already purchased properties through the firm. The third party was a close family member, and there were no other red flags associated with the transaction. Retrospective due diligence performed by the firm did not highlight any further concerns. So this resulted in a £2,000 fine for her personally, using the fining guidance that was in force at the time. It's worth pointing out that the level of fine would now be significantly higher for her if the case had been resolved post the end of May this year, when our new fining guidance was published. Now over to Firm B.
So Firm B was an investigation that concerned a recognised body. It had 2 offices based in the Thames Valley region of England, and it was an intelligence-led investigation into the firm. We conducted a root and branch review of the firm's AML controls and reviewed a random sample of files at the firm. The on-site investigation was performed by our forensic investigation team, and as stated on the slide, they had picked up a number of failings, and that was that the firm had failed to have a compliant regulation firm-wide risk assessment in place until the summer of 22, some 5 years after the regulations came into force. And that further, the firm had made an incorrect declaration to the SRA in 2020 about having a compliant firm-wide risk assessment. And so this led to a failing of having sufficient regards to our warning notices on the same, which were first published in May 2019, the LSAG guidance, and further the SRA's sectoral risk assessment. In addition, the firm failed to put in place adequate PCPs, formerly policies and procedures under the 2007 regulations, and it did not audit those PCPs either. The firm failed to train relevant staff adequately, failed to perform client and matter risk assessments adequately or at all until 2022, and on some exemplified files, failed to undertake necessary source of funds checks and to retain CDD documentation. This case highlights multiple failings at both firm and file level that the firm admitted to at the conclusion of our investigation. And so we settled this matter by way of a regulatory settlement agreement for the sum of £20,000. On to case study C.
Okay, this is in relation to Mr. C. This investigation started with a report from law enforcement about an elderly gentleman who had his home effectively sold from underneath him to a family member via an LPA. That family member was subsequently convicted for fraud. But the actions and inactions of Mr. C, an experienced conveyancing solicitor and partner at his West Midlands-based firm, was so serious that the matter proceeded to the Solicitors' Disciplinary Tribunal owing to its greater sanctioning powers. So Mr. C, what did he do? He failed to handle the sale of the client's property in a manner which protected the client's interests, in that he failed to advise or ensure his client understood the risks and implications of selling his property in exchange for, in part, non-monetary items, namely a diamond ring and a car. He failed to take or cause to be taken any adequate steps to verify the buyer's valuation of the car and of the engagement ring or their title to those assets. For example, the ring was valued at over £50,000 according to one A5 size document, with no further verification or checks completed as to the authenticity of that valuation or ownership. As a result, he was found to have failed to conduct adequate CDD and ongoing monitoring of the business relationship, and failed to conduct EDD also. The tribunal also found him to be manifestly incompetent in light of his failing to act on the numerous red flags associated with the transaction, and suspended his practicing certificate for a period of 12 months. One of the pre-submitted questions that we've had to the webinar concerned this type of non-traditional transaction where assets such as property are exchanged for alternative high-value items. These types of transactions carry increased risks, and solicitors need to be live to the red flags in our warning notice and use their experience too. Ultimately, it is up to the solicitor and the firm to identify and assess the risks associated with any transaction and ensure due diligence is adequately performed, and also make sure that the client is fully advised and aware of any pitfalls that they may face. Now over to Firm D.
So this investigation started with a report from our AML proactive supervision team following an AML compliance inspection in 2021. Firm D is a recognised body based in the northeast of England. The compliance inspection found that the firm-wide risk assessment was non-compliant, and therefore the declaration the firm had made to us a year earlier concerning it having a compliant firm-wide risk assessment was also incorrect. The firm-wide risk assessment was in place, but it contained a lot of templated text and it was not tailored to the firm in 4 out of the 5 key areas as set out in Regulation 18, namely risks surrounding clients, jurisdictions, delivery channels and transactions. On highlighting the areas of non-compliance within the firm-wide risk assessment, the firm put things right straight away. And also of its own making, the firm conducted a full audit and a review of its PCPs to ensure it was best placed to identify and capture any money laundering risks it faced. The declaration made in 2020, as I referred to earlier, was ultimately shown to be incorrect, but it had been made in good faith, as the firm at the time believed that their firm-wide risk assessment was compliant. The firm was sent a notice raising allegations, but ultimately our matter concluded without sanction, and in this instance we issued a letter of advice and a warning as to future conduct. Just before we pass back to our Chair Mandy, it is worth reiterating that our new fining guidance was published in May 2023, and so this will have an effect of, in certain circumstances, an increased level of fine, as the new guidance focuses on the turnover of firms or the earnings of individuals more so than it has done in the past. Just before we hand over, I just want to say thank you very much for your attention during this part of our presentation, and now I'll pass you back to Mandeep.
Thanks, Christian and Nicola. We've had quite a few questions in, so we're going to move on to Q&A now. And the first question is, how far back should you go if funds have accumulated via savings?
Yeah, I can take that one. So what you need to do is go back as far as is necessary to understand the source of monies in such, and in some cases this is easy and others less so, bearing in mind that in EDD situations this requirement is more stringent, and in the case of PEPs both source of funds and source of wealth checks are mandatory. On a practical level, when you obtain bank statements in support of the source of funds checks that you're performing, you need to ask yourself, are the bank statements commensurate with your understanding of the client's background and their financial position? What are your client's job and business interests? It simply isn't enough to gather the statements in and place them on file if you're not going to read them or scrutinise them. Generally speaking, and from experience, I would say as an example that if you were in the possession of 3 months worth of bank statements to support your checks on deposit monies to be used in a conveyancing transaction worth £400,000 and your client was employed, for example, as a security guard on circa £12 an hour, then it stands a good chance that he or she did not accumulate around £300,000 in savings by themselves. The monies may well be genuine, but you need to check things out. So if the accounts are showing you that he or she has accumulated their savings by way of a series of deposits appearing as loans or gifts or transfers from Dubai in the last few months, but prior to this intended property purchase, your client's take-home pay was in the region of £1,600 per calendar month, and they only had £9,000 worth of savings prior to this, then you would be justified in requesting further statements and a further explanation from the client so as to further understand their source of funds. If the majority of the deposit funds were from an industrial accident, personal injury settlement or inheritance, then again your client would be able to demonstrate this to you with ease and provide supporting documentation. There is no issue in you returning to your client to ask for documentary evidence and ask for an explanation and conduct those necessary checks. In some cases, this could mean going back several years and over various sets of accounts. Finally, it's important that you remember to document the extent of your source of funds checks in order that you can show you've complied with your ongoing monitoring obligations. And by way of an example, we have actually investigated a case where there was a cleaner who was on minimum wage, managed to save over £20,000 over a period of around 18 months to fund her deposit for a residential property transaction. Retrospective checks, which we asked the firm to do once we started investigating, showed that she had a secondary income from illegitimate means. The firm in this case was fined by us.
Thanks, Christian. Next question we've had in is, do the SRA inspect larger firms as much as it does the smaller firms?
Hi, thank you very much. I'll take that question, Mandeep. So yes, we do. We've got a rolling inspection programme which visits a broad range of firms across both England and Wales. And our inspections are targeted on the risk profile and the firm's size and nature being one of those factors. The number of firms we inspect is set out and published in our AML annual report. And we also have a programme of work where we look at independent audit functions of our larger firms.
Thanks, Nicola. Third question, how do you check a foreign trust which shows as the ultimate beneficial owner as an entity but gives no other details? Do I ask the client for full names, date of birth and addresses of all persons benefiting from the trust?
Yes. When you're doing CDD on a trust, you must obtain the trust document. That's key. It should name the trustees, the beneficiaries, the settler, and on occasion, the watchdog if one is appointed. Sometimes identification of the beneficiary gets complicated if the settlers and trustees are corporate entities where they have their own layers of ownership. The trust deed should provide all the information you require, and you should be aware of clients who are not cooperating in providing full disclosure or such information. You should also be aware if the client is unwilling to provide or you are unable to corroborate the full extent of the beneficiaries, then you need to consider why this is the case and adopt a risk-based approach. Sometimes it may mean refusing to act and terminating the business relationship. For example, if the information was provided by a regulated trust and company service provider in a low-risk jurisdiction, then you may choose on a risk-based approach to accept this in the absence of a trust deed. Alternatively, if the information came from a higher risk jurisdiction, such as the Cayman Islands, you may want to seek further assurances to be sure you have fully complied with your CDD obligations. It's worth noting in some circumstances we have discussed, I would suggest you consider your obligations in making a report to your firm's MLRO, or at least a discussion with them, and as stated, exiting the business relationship, unless of course you can derive a level of comfort from peeling back the various layers of client ownership and or funding introduced to a transaction. Those obligations are of course under POCA and should be considered if you have a knowledge or suspicion of money laundering.
Thanks, Christian. Another question, is the SRA going to start using fixed penalty fines for breaches now it has the power to do so?
Yes, we've already started some work on issuing fixed financial penalties in relation to our transparency rules, and they concern the level of information that firms need to give to clients or potential clients. We've also been issuing notices in cases where firms are not complying with requests for information from us or have failed to engage with us. At this stage, though, we are, in the AML team, not issuing fixed financial penalty notices for breaches related to the MLRs, but this may be something that could happen for the lower or more technical breaches later down the line. An example of this may be for isolated instances relating to a failure to nominate a MLCO or money laundering compliance officer, because essentially what we're already doing is considering notices to those firms, a little like we do with our Colp and coffers, where they've not been in place for a period of time after a Colp or coffer may have left the firm. And so it is something that we're thinking about, but we haven't made a decision yet at this stage.
Thanks, Nicola. We've had another question in, but I'd like to be wrong. Am I accountable or have I fulfilled my obligations?
Okay, I can take that one. I mean, so it's about running somebody through an electronic verification checker and then coming back green. I mean, using an electronic checker is just one part of your customer due diligence obligation. So you've got to identify and verify your clients. So if you're not meeting them in person, that increases the risk straight away. But you'd be looking for standard forms of ID, passport, driving license, etc. If you're meeting them in person, that's even better. And electronic IDs are good, and they point out, for example, where a party may actually be deceased, which we've seen before, and so it's a useful tool in your arsenal, but it's not the be all and the end all of your customer due diligence obligations. So I would say continue to use them, but make sure you've collected enough information and documentation that you can be as sure as you can be that you are acting for who they say they are, and that the transaction and the client are as bona fide as you would want them to be.
Great, thanks, Christian. Another question we've had in, are there any sources which you recommend considering for the purposes of determining whether a jurisdiction is high risk for AML purposes?
Yeah, I'm happy to answer that question. So, you know, notwithstanding obviously the high risk jurisdictions list, one of the things that I would point firms to and say that you should have, you know, an awareness of is the Transparency International guidance guidelines. They publish a lot of firms, a Basel index as well. It's also a really helpful, useful resource when considering your appetite for risk with the client or the matter. So they would probably be the two resources that I would consider.
Thanks, Nicola. Another question we've had in, how do you check, aside from the regulations on the outside guidance, what advice would you offer firms or solicitors to assist us in protecting ourselves from becoming victims of organised criminals targeting our firms?
It's a good question. There are organised criminal OCGs, organised criminal groups out there, and it's one of those things that could happen. So you've got to look out for the red flags, really. There are numerous red flags that we've highlighted in our warning notice on money laundering and terrorist financing that we first issued in December 2014. It was updated in 2018 to take account of the 2017 regulations coming into force, and it's been updated once or twice since. Some of the examples on that warning notice are things like clients being secretive about who they are, being secretive about the reason for the transaction or the source of the funds, use of an intermediary or another vehicle to disguise the identity of the true client, things like unexplained urgency, requests for shortcuts or changes to the transaction, particularly at the last minute, further instructions to retain documents or to hold money in your client account, or requests to make payments to and from third parties, which of course may actually breach one of our accounts rules as well, client account as a banking facility. You should also be aware of repetitive instructions involving common features, parties, or back-to-back transactions, especially where the assets rapidly change in value. You should consider if the transaction is unusual for the client or the type of business. As we saw earlier in the example, I think it was Mr. C, use of a power of attorney or trust vehicles in unusual circumstances, and companies who have also been recently set up and have no accounts published. All those are sort of red flags which make it higher risk, which means that you should be doing a bit more to try and understand what's going on. Examples like clients who are not local to you, who cannot explain why they're using your firm to represent them. So we've seen an example of a firm in the northeast being chosen by a client who lives in West Wales to buy a property in London, and so just have some thought as to why we're being instructed by this person, and other warning signs that you can find in reports by the Financial Action Task Force, so FATF. The NCA has some useful publications, and obviously, if you've got any queries or any issues on any matters, we urge you to go and speak to your firm's MLRO. It's worth just discussing these things and being open and saying, I think I've got an issue with this case or with this client or with this transaction. Do you think I need to do anything else? Because normally two sets of eyes on a matter, you can normally come up with the answer, and you need to ask your client some more questions.
Thanks, Christian. We've had quite a few questions in about whether the slides are going to be available. So the slides and a link to this video will be available on our resources page after the webinar is concluded. Had another question in on source of funds. So do you need to do source of funds checks where a client is long-standing and its source of wealth is well established?
Okay, well, source of wealth is only mandated for politically exposed persons and close known associates of politically exposed persons, along with since the 2019 amendment regulations came in, high risk jurisdictions being involved. So for a long-standing client, I think the LSEG guidance says that it would be wise to refresh your customer due diligence documentation every 2 to 3 years or something like that. So get up to date passports, utility bills, etc., just to make sure that you can evidence that you know who you're acting for. Now, obviously you do, because you've been acting for that client for a long time. But in terms of the source of funds for a particular transaction, then this should be easy for the client to show you. So if it's an individual and they, for example, a property developer, they should be able to show you their accounts, the money's coming in, the money's coming out. This is something that they would regularly be doing. They should be able to provide you with bank statements. It's gone are the days of maybe 10 or 15 years ago where you could just take it on trust of your client that you went on their say so because you'd known them and they've been a client for a long time. But source of funds checks are obviously under Reg 2811A. They're only needed where necessary. So you have to assess in each and every transaction whether or not you believe it necessary to perform source of funds checks. You should be on your individual client and matter risk assessment, categorizing your risk level for that client, matter or transaction, and you should be saying why you don't think you're going to get some things and why you should be getting other things. And so if you don't think source of funds checks are necessary, you should record that you're not going to do them and the reasons why. If you are going to do them, your client, if they're a long-standing client and have legitimate enterprises, they should be able to provide the information that you're after fairly easily.
Great, thanks Nicola and Christian for today. Just again to reiterate, the slides and the link to this video will be available on Watchback on the resources page for this event. If we haven't had time to answer your questions today, we will look through them all and see if there's something we can cover in future webinars and communications. On that note, we really want to hear what you thought of this webinar today and today's events. Was it useful? What type of content would you like to see covered in the future? And it would be great if you could click on the evaluation link below this video stream and let us know what you think. It will only take about 2 minutes to complete and will really help us improve. If you are planning on watching the final session, please complete the evaluation at the end of the day. We will email the evaluation link to registered delegates at the end of the day to remind you. Thanks again and goodbye.